On to the introductions. For those of you who don't know me, my name is Charles Livingstone. I'm a partner in the Government Regulation and Competition team, and as well as doing public law and other things for local government, I lead our competition practice and have subsidy control within that remit. And I'm joined today by Jamie Dunn, who is a senior associate in the team, who many of you will know, and who also does a lot of work in the subsidy control space. So in terms of what we're going to cover today, we are going to spend a little bit of time just recapping the changes made by the Subsidy Control Act. We're not going to go into that in as much detail as we have in previous webinars, because we're conscious that many of you will be pretty familiar with it, but we're just as conscious that there may be people coming to it fairly fresh. So we'll give you a high-level recap of what it is and what it does. But then the new bit, the real draw for today's webinar, is to look at some of the key lessons that we can take from things that have been happening out there in the subsidy control world, and also from our own experience of advising clients. So the Act itself, Subsidy Control Act 2022, has been in force from the 4th of January at the start of the year. So we have now over 10 months of it functioning. It's a more detailed domestic regime than the Trade and Cooperation Agreement that immediately followed Brexit. So that's the TCA. The TCA was a very pared back version of the EU state aid regime. So a lot of the detail kind of disappeared for a couple of years. The Subsidy Control Act has then reintroduced quite a lot of detail, but it's not always the same detail. So it gives effect to the subsidy provisions of the TCA, but it also puts a lot more meat on those bones, or a lot more gold plating on it, if you prefer that metaphor. The principles and rules in the Act apply with some modifications to subsidies that are provided by means of devolved primary legislation, so Acts of the Scottish Parliament, most relevant to our audience. UK Parliament legislation is not within the scope of the principles and rules that are set out in the Act, or the remedies that parties can pursue. It can be voluntarily referred to the Competition and Markets Authority for a review, but it's otherwise, the Act doesn't otherwise constrain the UK Parliament, which is really, it's consistent not only with the TCA, but also just consistent with the kind of constitutional principle that Parliament cannot bind itself. But Parliament can bind devolved legislatures, which is the reason that devolved legislation is within scope. And the Act provides different potential routes for providing grants and subsidies in other forms and shapes and sizes. So outside the Act itself, we then have a number of pieces of secondary legislation. So setting out the detail on subsidies and schemes of interest or particular interest, which I'll speak to a little bit later. Regulations on how to calculate cash amounts and cash equivalents, requirements on the information that needs to go into the subsidy database, and the CMA's information gathering powers. And in addition to that secondary legislation, we've got statutory guidance on subsidy control from the UK government. The CMA has issued guidance on the operation of the Subsidy Advice Unit. There is also a principles assessment template, and there are some streamlined routes, which again is something that we will cover, and Jamie will speak to those. Beyond what's on that slide, the guidance is probably the one that will be most use on a day-to-day basis. So that's statutory guidance that's published by what is now the Department for Business and Trade, which was BEIS at the time it was published, about the practical application of various subsidy questions. So that includes whether there's a subsidy, and that includes the rules on when an authority is acting in the way that a commercial market operator would. The subsidy principles, the requirements of the Act, the exemptions under the Act, the rules on subsidies and schemes that are of interest or of particular interest, and the general prohibition on misusing subsidies. So if you are somebody who works with subsidy control on a regular basis, you should really be familiar with what the guidance says about all of these and other matters, not only to help you help you with your day job, but also because the Act at Section 79 says that authorities do have to have regard to that guidance when giving a subsidy or making a scheme. So with that, I'm going to hand over to Jamie to talk a little bit more about some of the Act's provisions.
Thanks, Charles. So to start with, a reminder of when what you're dealing with is a subsidy. There are 4 conditions that are set out in the Act. So a subsidy is financial assistance, which is given directly or indirectly from public resources by a public authority. So some payment or transfer of value that comes from a public body to somebody else. And we'll come back to how that has evolved in a couple of slides. It has to confer an economic advantage on one or more enterprises, and that is really where the question of commercial market operator that Charles just referred to comes in. So if the public authority is acting as a private investor or lender would, then there's no economic advantage that's going to be conferred. But if things are on more favourable terms or a straightforward grant or something like that, then the economic advantage test is likely to be met. It has to be specific, so it has to favour the recipient over other people with respect to production of goods or provision of services, and it has to have or be capable of having an effect on competition investment within the UK or trade or investment between the UK and another country or territory. And we'll come back to that in a little while as something that has changed from the way the world was before. So once you know that what you've got is a subsidy, the most sensible place to go next is whether it is a prohibited subsidy. There are certain categories of subsidy that the Act says are prohibited. You just cannot do these, and these are unlimited guarantees, either with regard to the value of the guarantee or the duration of the guarantee. You cannot have a subsidy that's contingent on export performance. Or the use of domestic over imported goods or services. That's not to say that it cannot relate to or support exports in any way, only that the subsidy cannot have that as some sort of condition or requirement in order to be released. The subsidy can't be contingent on the recipient enterprise relocating existing economic activity, either in whole or in part. It can be to do with setting up in new areas, but that has to be genuinely incremental on what was before, not just a relocation. And no subsidies for rescuing ailing or insolvent enterprises. Again, not the same as no subsidies to ailing or insolvent enterprises, but no subsidies for rescuing them. And there are quite complex rules around when that's triggered and how it works. Subsidy schemes are essentially an overarching set of rules that govern a number of subsidies that can be given under the scheme, and a scheme can be made by any public authority to cover subsidies that it gives out itself. Sometimes it's useful to think of these as similar to a procurement framework. So you follow a single compliant process to set up a scheme, as you would a framework in public procurement. And in doing that, you've created a safe harbour that protects any, in the case of a framework, contract awarded under it, in the case of a scheme, any subsidy awarded under it. Don't take the comparison too far, though, because that still ties back to the first point there, which is that a public authority can only create a scheme that covers subsidies it makes. You cannot, for example, as one council, create a scheme that other councils can use, only a scheme that will protect subsidies that you yourself go on to give. So how does that play out in further practice? Well, the requirements of Part 2 of the Act don't apply to subsidies given under subsidy schemes. So that's all your stuff around assessments of compliance with principles and so on. And that includes under a streamlined route made by the UK or a devolved government. I'll come back to that in a little bit more detail, but the key thing is that those streamlined routes can cover subsidies given by other public authorities, which is the difference with regular schemes that any public authority can make. If the UK government or a devolved government does it, then it can be available for use by others. There is an exception for subsidies of £100,000 plus, which are made under schemes, which is to say that those have to be reported on the subsidy database. Now, subsidy schemes are otherwise prohibited to the extent that they provide for subsidies that would themselves be prohibited. So what you cannot do, for example, is set up a scheme that covers subsidies that are contingent on export performance, to take that as our example, because if you cannot do it for a single subsidy, then you cannot do it for a scheme that covers multiple subsidies. And that all plays into the assessment of the scheme when you're setting the scheme up. And then finally, and we'll come back to how referral works in one of Charles's slides in a little bit, but subsidies that are made under a scheme aren't subject to being referred to the CMA, even if the scheme itself is, although there's a sort of more complex divergence from that for tax measure schemes. So just looking at streamlined routes in a little bit more detail, as I say, these are your national, if you like, subsidy schemes that are available for use by any public authority when giving a subsidy. So they can be made by the UK government to cover any public authority in the UK, or by one of the devolved governments to cover public authorities within their devolved area. What they will do is allow and do is allow public authorities to give subsidies without needing to carry out, in particular, an assessment against the subsidy control requirements each time they want to pay something out. So if you've got a streamlined route that covers all subsidies of a particular description, and again, this is the same as with a subsidy scheme, then any subsidy of that description can be made without having to go through the full procedural requirements that the Act otherwise imposes on individual subsidies. In some ways, it's a bit like the general block exemption regulation that we knew and loved under state aid. It says, in effect, this is pre-approved and you can do it without having to go through other mechanisms. Obviously, the difference with GBER is that whereas state aid was generally prohibited to the extent it wasn't permitted, that's not how subsidy control law works. Subsidy control law says that you can give a subsidy, you just have to follow certain procedural requirements and rules before you do it. But in the case of subsidies that fall under schemes or streamlined schemes, most of the work has already been done either by you or by somebody else for you. And it allows for essentially fast tracking subsidies for things that are more routine or less distortive. So what kind of example do we have so far? Well, we've got 3 streamlined routes that the UK government has published. Those were the 3 they said they would come out with before this came into force, and they are still the only 3 that we have. Research and development, energy usage, which I sometimes think is slightly misleadingly named. Actually, clean heat is one of the big categories of the energy usage streamline scheme. So if you are looking at promoting a district heating scheme, for example, I would encourage you to look at the energy usage streamlined route, even though it doesn't sound on the tin like it might be relevant to you. And local growth, essentially that sort of levelling up agenda, and all things connected with that. As of, I think, about 6 weeks ago, the last time I saw anybody at the DBT speak about this, it was quite clear that there are no others currently in the pipeline from the UK government. And also, nothing has yet been put out using this by the devolved governments, and certainly the indication from the Scottish government is that there's nothing on the way there either. So for the time being, if you're looking at relying on something somebody else has made for you, then really these 3 streamlined routes are it. But of course, you can create your own scheme for yourself rather than having to go through the full gamut every time you want to give an individual subsidy. Legacy schemes are a potentially useful thing for public authorities that have been doing this for some time. So a scheme that was created before the 4th of January 2023, when this came into force, is essentially grandfathered into the new regime. So you can carry on using a subsidy scheme that was made before the Act came in on its own terms without having to consider, in essence, how that works under the new Act. And that can, in theory, continue indefinitely, albeit it's almost certain that in order for the scheme to be compliant when it was made, compliant with relevant rules when it was made before the 4th of January, it will probably have some sort of time or value limit on it. If you're continuing to award under those schemes, then there's no requirement to assess it against the subsidy control principles or comply with the other requirements around prohibitions and so on. The exception again to that is transparency. If you are awarding higher value subsidies, then those have to be published on the UK government database, even though they are being given under legacy schemes. And a key point really, their legacy schemes can be modified. You can change them, you can extend them, add value, tweak the terms and conditions and so on, provided that there is a mechanism for that within the scheme itself. So if the scheme allows for it to be modified, then you can keep modifying it. But again, you just have to comply with the rules as the scheme set them up originally. Charles.
Thank you, Jamie. So I am going to speak briefly to subsidies of interest and subsidies of particular interest, which we've mentioned a couple of times. Not going to spend too long on the detail of the thresholds. They're all on the slides. You can see them and you'll get them as follow-up. The most important category are subsidies of particular interest or schemes of particular interest. The reason for that is that they must be referred to the Subsidy Advice Unit at the CMA before they are given in the case of a subsidy or made in the case of a scheme. And these are for subsidies that clear certain thresholds that suggest that they are likely to have a more distortive effect on competition, more impact on the market than subsidies that are either of lower value or are in less sensitive sectors. So if you have a subsidy that is over, if it's over £10 million by itself, then it qualifies. If it's over £1 million and adding it into other related subsidies totals over 10 million, then that subsidy has to be referred to the CMA. Similarly, if your scheme provides for the giving of subsidies over these totals, then that's when the scheme would be notified. And there are provisions about what you take into account when you're doing that accumulation. Alternatively, if you have a £5 million either value by itself or accumulated total, and the subsidy concerns a sensitive sector, mostly around types of manufacturing, then it will also have to be referred to the CMA, as does anything that's over £1 million that involves relocation or any subsidy that's for restructuring purposes. The first three categories there, if it's a rescue subsidy or it's about deposit takers or insurance companies, you can see the caveats to those, but generally, well, other than rescue subsidy, you won't tend to be too concerned about those. So you need to make sure that you always have those thresholds in mind, because if you fail to refer to the CMA, then that subsidy is going to be wide open to challenge. The lesser category of subsidies or schemes that are just of interest, that's a less critical thing to get right, because in those cases, there is the ability to refer it to the SAU for a review, and the authority itself can refer that, or the Secretary of State can refer it to the SAU if the Secretary of State has some concerns about it. So the conditions there, you have to start with not being of particular interest, so you don't meet any of the first set of thresholds, but you have a 5 million threshold for the subsidy either by itself or with related subsidies, or if it involves relocation, rescue, liquidation or liquidity of financial services companies, basically, or if the subsidy is given under a subsidy scheme that is made in the form of a tax measure. So that's one to sort of keep your eye on. But there are yeah, it's important to make sure that you're understanding these thresholds, and you may well want to take advantage of the ability to refer to the SAU if you have a subsidy of interest or a scheme of interest. And speaking of referrals, so the process with the Subsidy Advice Unit, referrals are made through the SAU's Public Authority portal. There's then a process that's gone through, so it's 5 working days for the SAU to decide if it's a voluntary referral. They will decide whether they want to take it on and report, because they don't have to. It's not mandatory for them any more than it is for you. or there's 5 working days if it's a mandatory referral to confirm whether the referral contains all the necessary information. Now, it's worth noting that the CMA only publishes referrals once they have accepted them and agreed to report on them. So if you refer something and the CMA says no, we're not going to prioritize that, then that won't be published. Once the SAU has taken it on, they have 30 working days to assess it and report. You can extend that by agreement. There needs to be a publication that shows that that's been done. If it's a mandatory referral, the Secretary of State can extend it up to 40 working days at the request of the SAU. That process, again, is public, so just be conscious of the publicity around that. If it is a mandatory referral, then after the SAU has issued its report, there is a 5 working day cooling off period for the authority before it can give the subsidy or make the scheme. And again, the Secretary of State has power to step in and extend that up to 30 working days if there are serious deficiencies identified in the notice. Where a report is issued by the SAU, that is published. As far as we know, there is no sort of embargoed copy or anything given to the authority, so make sure that you do have your PR ducks in a row if you think it's something that is likely to attract commentary or criticism. So that's the process. In terms of some lessons that can be taken from the reports that have been issued by the CMA, there have been 16 referrals to date. If you go on the CMA website and you filter its cases by reference to this, you'll actually see 17, but that's just because there's a Welsh language version and an English language version of one of them. So there have been 16 referrals. 3 of them are still open. The other 13 have been reported on. Energy and environment are the most common topics, the most common sort of subjects, reasons for subsidies being given that are then referred to the CMA. The reports tend to be in the ballpark of sort of 20, 25 pages, that sort of thing. They do have a summary. So if you're minded to go and read them all and see what sort of lessons you can take from them, you can. We haven't gone through them line by line or anything like that, but we have picked out a few that have some potentially useful lessons. So the first subsidy proposed by Birmingham City Council to a private company, one of the key lessons that the CMA identified there is the importance of providing the CMA with all the available evidence and analysis to let it carry out its assessment. And in particular, provide the CMA with everything to demonstrate that you have properly considered the alternatives to giving a subsidy, so including a no subsidy situation, but also different types of subsidies that are structured differently, lower value subsidies, that sort of thing, and also to show that you have considered the negative impacts of a subsidy. I'll come back to that one. The only Scottish referral that's been reported on, there's one that's still open with Dundee City Council and Loganair, but the only one that's been reported on is with High and Sumitomo Electric Industries. And one of the points that we've pulled out from that the CMA flagged was that it's helpful to consider if benefits might affect if the benefits of the subsidy might affect the incentives of the beneficiary or of other players in the market compared to the no subsidy counterfactual. So again, that's just really thinking through all the consequences of the subsidy that's proposed. And then probably the most interesting one is Warrington Borough Council and Livewire. So this is a council-established community interest company that was set up to run leisure services and library services and certain health and wellbeing services, but was in real financial difficulty. And the council was proposing to support it. There was a real lack of clarity over what subsidy was proposed, what the council was actually planning to do, what aspects of what it was planning to do was a subsidy. So whether it was everything the council was planning to do or just an increment on what it had previously done. And the goalpost kept moving there and the council never really quite pinned it down. And it just runs through the CMA report that lack of clarity, that moving target, made it very difficult for the CMA to assess the position. And it meant that their report ended up being quite uncertain and quite heavily caveated. So probably had very limited value for Warrington Borough Council. And probably if somebody was minded to challenge the giving of that subsidy, the CMA's report would not really offer the council very much protection. The CMA also identified the desirability of considering the services that the company was providing separately and considering the impact of the subsidy on each of those individual markets rather than bundling them all together. It's also worth noting that this was intended as a restructuring subsidy, but one of the requirements of a restructuring subsidy is that it should provide the company with a path to viability. And the council's referral to the CMA didn't actually address that return to viability. The suggestion just seemed to be that there would be ongoing subsidy into the future. So moving beyond the CMA reports onto some of the things that the CMA has said in presentations and conferences and things like that. So just a bit of intel really. So the CMA is trying to avoid using the powers that it has to demand information. It's tending to work on a much more kind of voluntary basis. This isn't on the slide, but there have only been 2 referrals where they've really had any third-party involvement in the process. But in one of those cases, the CMA has said that it actually found the private sector contributions very helpful. So that may be something to think about from an authority perspective. If you for example, have spoken to people in the market and they're not concerned about a subsidy, then you might want to get them to chip in their tuppence worth with the CMA. Another lesson that the CMA have highlighted that kind of runs across a lot of their reports is that public authorities are, or they have seen public authorities being a bit too quick to point to a market failure. So for all subsidies, you have to be able to point to either a market failure or an equity rationale for the subsidy to be given. And Jamie will say a little bit more about this. But the CMA thinks public authorities have been going to market failure too easily. And in particular, have been treating market failure as if it's synonymous with market forces producing a socially or politically undesirable outcome, and that's not the same thing. So the CMA's message is that you're probably best looking at equity rationale in most cases as your first port of call, but whichever basis you choose, make sure that that's recorded and it's justified and you've explained your thinking on that when you're making a referral to the CMA. Another tip is that the CMA has seen a lot of authorities seeking to either downplay or even refuse to accept the existence of negative effects or potential alternatives to a subsidy, or arguing that, okay, there's a subsidy, but it's not going to affect competition. The CMA's position is that, by and large, by definition, a subsidy is going to affect competition. And it's also going to have negative effects, and there will always be potential alternatives. So if you're going to be going to the CMA, and indeed, even if you're not, even if you're just doing your internal analysis and you want to make sure that it can stand up to any challenge in the future, you should be accepting the existence of these things and dealing with them head on. The CMA has also got the impression that authorities are finding, so of all the principles that have to be followed, Principle F is the one that authorities are having the most difficulty navigating. So Principle F is the need to minimise any negative effects on competition or investment within the UK. And the CMA's recommendation is to make sure that that is considered expressly and that the view that's taken on it is properly substantiated. They also flag the need to actually read and consider and action the CMA's views. So if you get a report back from the CMA that identifies difficulties with your assessment, don't just say, well, okay, but it's not binding, so we'll just crack on anyway. You should actually consider them, and if there are ways you can improve either the assessment or the subsidy configuration and design itself, then it's kind of a no-brainer to do that. Because if you don't do that, then you're kind of leaving the door wide open to a challenge in the Competition Appeal Tribunal. And the CMA will not, they won't simply defer to experts, but if you have had expert input on, effects on a market and on competition and that sort of thing, plenty of economists specialise in things like that. And indeed, competition lawyers can be quite good at that sort of thing. That will tend to give the CMA comfort about the assessment that's been done. And just generally having different pairs of eyes on it, sort of a critical friend type of approach to an assessment can be very useful, because often, particularly if the assessment is drawn up by the sort of people who are in charge of the project that's conferring the subsidy, you can often read it in a way that you can read it differently from other people because of all the knowledge that you already have. So you can infer things from language in an assessment that isn't necessarily going to be obvious to somebody who's coming to it cold or hasn't been living it in the way that a project team would have been. Then just finally from me on lessons learned, some cases. So British Sugar and Bulb, these are both under the TCA rather than the Subsidy Control Act. They predate the Subsidy Control Act, but they're still worth flagging. So British Sugar, this was a complaint that the UK government was giving a subsidy to Tate and Lyle by permitting the import of a certain volume of cane sugar tariff-free. And they argued that that was a subsidy because Tate and Lyle was basically the only refiner of sugar that imported sugarcane, because British Sugar and others used UK and EU sugar beet. So the lifting of tariffs on a certain volume of sugarcane, they argued, was a subsidy to Tate and Lyle. And the court just wasn't having it there, said that a measure isn't necessarily a subsidy just because it happens to advantage a particular business. The tariff quota in question was available to anybody who wanted to buy sugarcane. It just so happened that Tate and Lyle was the company that bought most, if not all, of it. The bulb case, that was about the transfer of Bulb's energy customer base to Octopus. The key point to take from that is that that challenge was rejected because of undue delay, even though it was only brought a couple of weeks after the decision was made. Now, undue delay is specifically in the Subsidy Control Act as a basis on which the Competition Appeal Tribunal can refuse to give a remedy in a subsidy challenge. So where a subsidy is kind of critical to a business's survival or something like that, or indeed to avoiding the very bad consequences for customers of a business going down without some sort of arrangement being made, such as transferring their customers or temporary liquidity support or something like that. Then if that decision is time critical, then a challenge that's not made pretty much immediately is going to be in big trouble. Beyond that point, the court set out that the test was kind of a judicial review test, so would look at whether there were relevant considerations missing or irrelevant considerations taken into account, whether the authority had acted reasonably, including whether it had taken expert advice, and basically conferred a significant margin of appreciation when it comes to things like proportionality. One point that goes back to something I was saying and that Jamie will touch on, the court had difficulty seeing how the government could rationally conclude that the unwillingness of the loan market to fund a company that was in financial difficulties was a market failure. So that's kind of illustrative of the point that I had on the previous slide. And then Durham County Council, a very significant case in the sense that it marks a real change from the state aid regime. And the CAT there, this was under the Subsidy Control Act, said that a public authority cannot give a subsidy to itself. So that departed from state aid, because under state aid, a public body could also be an undertaking where it was participating in a market. But under the Act, it cannot be both the public body and the enterprise that's receiving a subsidy. So you need to have some separation between those two concepts. So this sort of in-house subsidy concept from state aid, that has not survived into the Subsidy Control Act. Jamie, back to you.
Thanks, Charles. So just to finish up then with some of the themes really that we've seen presenting clients with tricky situations or challenges, and how those work out, articulating how the project satisfies the subsidy control principles, so really of a par with what Charles was just saying about what the CMA, the SAU has pulled out of its report so far. Market failure or equity rationale as the justification, the policy objective of a subsidy. I think that there is a tendency, perhaps understandable, to start with a market failure justification and then try and articulate the situation that you're in order to meet the requirements to identify a market failure. There's no priority between market failure and equity rationale, and I think public bodies do need to recognise that equity rationale is just as good a reason to to promote a subsidy as an identified market failure, and therefore not identifying a market failure does not mean that the subsidy cannot proceed. It can proceed on the basis of the equity issue that's being resolved. Taking reasoning and the subsidy control principles on a standalone basis rather than looking at external factors. Lots of subsidies take place in the context of broader policy objectives, broader schemes, whether that's a growth deal or some sort of levelling up measure or general sort of regional economic programs. That's all very well and to the good, but you cannot simply rely on the fact that work has been done before in order to allow a subsidy to meet the subsidy control principles. That analysis has to be undertaken within the specific confines and specifically targeted at the subsidy that's being given. And then again, to tie back to some of the stuff that also comes out of the CMA's reports, the assessment process is a decision-making process by a public authority as a public authority. It's not a marketing exercise. This isn't about justifying yourself to somebody else. This is about justifying the decision to yourself. And so it's not marketing, it's not box ticking. It requires a lot of time to get it right. And it requires, in particular, looking at the negatives and fully sort of dealing with all of the negatives, embrace the negatives, if you like, so that you can make sure that you've taken them into account properly, and that there's no perception later on that you might have, for one reason or another, skirted over the downsides and therefore not properly taken them into account in a way that can undermine the decision that you reach in the end. Getting used to some of the differences from state aid, in particular, the loss of the purely local subsidy rules. So this was always a little bit theoretical under state aid towards the end anyway. It was typically the case that an EU dimension could be found to almost anything in the modern world. But certainly the rule that the assistance had to have a cross-border impact in order to constitute state aid is gone. And I think there has been a level of getting used to the fact that tiny little local subsidies, care homes is one instance where we've seen this arise, can be subsidies, even if there is no possible impact on any broader market that goes outside the UK or even outside the local area. That is enough. The formalities and the procedures of dealing with subsidies, and in particular dealing with things like minimal financial assistance and the boxes that have to be ticked in order to give assistance as MFA, and also things like the transparency requirements, making sure you're set up for the database, making sure you're getting all of the information that needs to go on the database under the transparency requirements, dealing with those. And then lastly, something that we've seen a lot of authorities, quite understandably in my view, struggle with has been how this interacts with third-party funding schemes, or what I call the whose assistance is it anyway, whose assessment is it anyway rule. That when you are, for example, getting money out of a growth deal, whether that's coming from sort of UK or Scottish governments, or we're dealing with applying to subsidy schemes that are administered by UK government departments or things like that, a lot of the time, and we saw this in particular in the context of the Levelling Up Fund, a lot of the time the body that is giving out that funding will say to another public body, will say to that other public body, can you please advise us that this complies with the subsidy control principles? And that can be quite challenging because it's not the public authority that is doling out the money on the ground that is necessarily the one designing the scheme that they're doling it out under. And so when it comes to measures such as have you minimized the impact on the negative impact or distortive impact on competition, that can be quite difficult because it's not you that's doing the minimizing, it's the public authority that has set the rules of that funding arrangement. So it's an additional challenge, but it is something that can be dealt with. And then obviously the point about differences of opinion. You may take a view that something is one way, but the public body that is in charge of the overall fund may take a different view on what is proportionate, on what is conferring an advantage, on what is selective, and so on. So there's a lot of back and forth that can come into those situations.
Okay, thanks, Jamie. So we'll take questions now. We have some questions to answer, but if you still want to submit one, then get it in now. In the meantime, while you're listening to our answers, you can peruse the list of webinars that are coming up that may be of interest to you. A couple of which I'm involved in, one with Jamie again. So hope to see you on those. In terms of questions, Jamie, can you consider the one about care homes? And I'll answer one in the meantime. So one question is there any specific subsidy control guidance for universities, both as a recipient and a provider of subsidies? In particular, is there any guidance on the applicability of the R&D streamlined route in the context of collaborative research projects undertaken by universities? Relatively simple answers to both. There isn't specific subsidy control guidance for universities, at least not issued by government. There may be guidance out there issued by university bodies or within universities themselves. In terms of guidance on the applicability of the R&D streamlined route, the answer to that is yes. The streamlined route is accompanied by guidance on it, and it does expressly reference universities, both in isolation and in the concept that it calls research and knowledge dissemination organizations. So yeah, if you sort of Google research development streamlined route guidance, you should be able to find that. So Jamie, question for you: are you able to give more information on the care homes example that you mentioned?
A little bit, not too much. This arose in the context of bringing certain care services in-house to a council, and the acquisition of property and the business as a going concern, and the value to place on it when doing so, and in particular whether that constitutes commercial market operator or not. The reason that this arose was because there was a bit of a back and forth between the council and the operator as to whether subsidy could arise at all, because it was a care home, it was purely local, and certainly the business I think had been used to the idea that that subsidy wouldn't matter to the sector that they were in because of the local nature of it. But in this instance, the council obviously had to take the position that that has changed under the new regime. We do have to identify a lawful route to doing this, particularly if we think we're paying over the odds. And so we have to go through all of those arrangements. So the council did identify a way through that, but the point is that it had to in a way that the business didn't necessarily anticipate.
Okay, thanks, Jamie. Then another one I'll give to you. In fact, I'll combine two questions here. So one question is, can you expand a little on the term equity rationale and what that means as a concept? And I guess you could combine that with the question, if market failure is not the same thing as an undesirable outcome, then what is it? So the two concepts, what are they?
Yeah, very quickly in the minute I have left. Market failure is about saying that the way that the market is operating is not leading to the most most advantageous distribution of economic resources. So a lot of the time, the market will say, for example, that funding isn't going to be available to X because all the funding is wrapped up in being made available to something else, and so market funding isn't available. That can be a market failure if that is not the most logical allocation of economic resources. But an equity rationale is really about saying that the outcome of the market's allocation of resources might be logical, but it leads to social problems. So it leads to lower employment in a given area, or it doesn't support certain activities in a given area, and so on. And really, that's where you're looking at the equity rationale situation, saying, well, the market isn't putting jobs here, so we have to intervene to do so. And a lot of the time, people look at that as a market failure. It's not a market failure. The market is doing what the market does, but it is an equity problem. And so what you're looking at is the social outcome, even if the market is doing what markets do.
Yeah, if you think about the bulb case, the court noted that it's not a market failure for private lenders to refuse to lend to a company that's on the brink of collapse. The market exists to keep financial resources away from companies that are on the brink of collapse. So that's a good example if you need to keep that straight. We're a minute over, but just got a couple of questions that I do want to take. There's one about the Durham case and council-owned entities, and whether council-owned entities can receive subsidy. Jamie, do you want to take that, and then I'll take the final question on economic advantage?
Sure. So the Durham case turns very much on the principle that the same entity cannot be both the public body giving the subsidy and the enterprise in a way that didn't apply to state aid. You could be both, but that's all it says, is that the same entity can't be both at the same time. A council-owned or a public body-owned business that is, for example, an alio is separate, and therefore it can be the enterprise while the public body giving it money is the public body giving it money, and therefore, yes, that would be a subsidy, all other things being equal.
Okay, and then just one more question. So economic advantage, will this condition be fulfilled even if the organisation receiving the funding is doing something at cost? So no profit is made from the grant and the funding is effectively a pass-through. So there are some nuances around that. That means it's not necessarily as straightforward as it might sound, but by and large, if an enterprise is just being paid to do something, and it's not being paid over the odds to do it, then that's not going to be a subsidy, because it's not conferring an advantage on the enterprise. It's just paying them to do what they do. If the funding confers on them a really good opportunity, or really strong credentials that will qualify them for other things in the future, then that's when things might get a little bit trickier, and you might need to think that through. And you might say, okay, well, let's see if we can get out the subsidy test somewhere else, or otherwise, is it compatible? But generally, if you're just paying somebody to do something or to give you something at the sort of price that is reasonable to pay for that, then you're kind of into commercial market operator territory, and in any case, you wouldn't have an economic advantage in that scenario. Conscious of everybody's time, we are happy to take other questions if you want to get in touch with us, and may be able to give you a quick answer. And if it's more complicated, are certainly always happy to help people navigate the subsidy control regime. Otherwise, that's it for today, and we hope to see you at another webinar in future. Thank you.
Thank you.